What happens when a defendant walks into court thinking they can outsmart a judge with courtroom word games? In today's hearing, we're about to watch exactly that, and it spirals almost immediately. The defendant in this case appears to be relying on a familiar strategy often seen in so-called sovereign citizen circles, refusing to acknowledge basic legal identity, dodging direct questions, and trying to challenge the court's authority before the case even begins. On paper, that might sound like some kind of clever loophole, but in a real courtroom, it's a recipe for disaster. And this judge? He has absolutely no patience for theatrics. From the very first exchange, the tension is electric. The judge tries to confirm something as basic as the defendant's name, but instead of a straight answer, he's met with evasive responses and pseudo-legal jargon. That's when the judge makes it crystal clear. This courtroom is not the place for games. What makes this hearing so intense is that you can see the clash happening in real time. One side trying to force a made-up legal theory into the process, and the other side enforcing the reality of how the law actually works. The judge knows exactly where this is heading, and rather than entertaining the confusion, he shuts it down fast. But the real drama begins when the defendant keeps pushing, challenging jurisdiction, resisting the arraignment process, and attempting to control the conversation while the judge steadily tightens control of the courtroom. This hearing is a perfect example of what happens when internet legal myths collide with an experienced judge who has seen it all before. Watch closely, because every time the defendant tries to gain leverage, he ends up losing more ground. And by the end of this hearing, the judge leaves absolutely no doubt about who is in charge.
These sovereign citizen characters that want to think they run the courthouse, you're not running this courtroom.
I'm not a sovereign citizen.
Well, okay.
But
Listen, there's nothing for you to say. You're charged with operating with the presence of drugs. You have the right to a lawyer. If you want a lawyer, I will give you a lawyer right now. If you don't want a lawyer, then I'm going to arraign you. I'm going to let you go talk to the prosecutor and see if you can resolve it. Do you want a lawyer to represent you?
at any time I could hire an attorney, right?
Sure.
Or I don't have to waive any rights for that.
I'm just telling you, you have the right to a lawyer by law through the MIDC.
Okay.
Okay?
Okay.
So I could give you a lawyer right now that will talk to you and represent you at this arraignment and pretrial, if you want me to. If you want to waive your right to a lawyer and say, Judge, I don't want a lawyer, I'm going to go ahead and arraign you. I'm going to explain the charge, possible penalties, and your rights.
Yes, sir.
If you decide you want to hire a lawyer, then you just tell me that and I'll let you go hire it. Okay?
Well, if I tell you I want to hire a lawyer, and what if I end up not hiring a lawyer? Am I in trouble or something?
I don't know what you mean. I can arraign you today, explain the charge and the possible penalties. If you choose to go hire your lawyer, I'm going to set a new date and go let you go hire your own lawyer.
Okay. Well, I was never served a summons.
I didn't ask you that.
I understand that.
I didn't ask you that.
You're trying to hold a free trial out of summons?
I'm the judge. I'm not a witness. You want to ask me questions, you're not asking me questions. You're going to only ask me questions about things that you don't understand. You're not going to ask me questions. I'm not a witness.
Yes, sir.
Now, I'm just asking you, it's a yes or no. It's very simple. Would you like me to appoint you a lawyer right now to represent you at the arraignment and the pretrial? Yes or no?
And when would the arraignment be?
Right now, as soon as you talk to the lawyer and the lawyer goes and talks to the prosecutor for you.
How can I properly defend myself if I've never been served for summons?
I'm not going to debate. They don't pay me enough to debate things with. I'm not going to debate.
Right here, the judge identifies exactly what he believes is happening, and it changes the tone of the hearing instantly. When he references sovereign citizen characters, he's calling out a pattern the court has clearly seen before: defendants trying to reject the court's authority by redefining who they are, how names work, or whether laws apply to them. These arguments may sound elaborate, but courts across the country consistently reject them because they have no legal basis. And notice what the judge is doing. He's not debating philosophy. He's bringing the process back to fundamentals. The defendant has been charged, and now the court must move through arraignment. That means explaining the charge, advising the defendant of rights, and determining representation. Those steps happen whether the defendant agrees with the system or not. This is where many defendants make a critical mistake. They think refusing to cooperate creates leverage. In reality, it usually does the opposite. Judges interpret stalling tactics as obstruction, and that can dramatically reduce the patience and flexibility the court may have otherwise shown. The judge is still offering counsel, still explaining rights, and still giving opportunities to proceed normally. But every moment of resistance makes the defendant appear less credible, and that raises the big question. Is the defendant standing on principle, or walking straight into a legal trap of his own making?
Those right, all those defenses, and I will listen to you.
So you will give me an attorney to talk to right now?
Absolutely, free of charge.
Did you say free of charge?
Free of charge. You're entitled to one. The state adopted these rules. It's not my rule, but they did that about 6, 7, 8 years ago now.
And an arraignment, you want a plea, or you want just to understand the charges?
You go talk to a lawyer.
I can walk out here right now and go talk to the lawyer?
Yeah, we're gonna give you one. I'll give you a lawyer. John, who will be his lawyer?
Probably.
Is Mr. Crawford here?
Yes, sir.
Who else do we have here today? Who? Who's Tony Carvin and Court Security? What about Christopher Shep?
Right now, attorney.
All right. So yes, we will set you up with a lawyer. You go right out in the hallway and he's gonna give you a
Well,
lawyer.
sir, I'm not fully sure if I want one. It's just an arraignment. You just want them to charges and I just want fully.
Arraignment is where I explain the charge,
Okay.
possible penalties, and your rights. Period. You can have a lawyer to do that with and come in here with a lawyer and have the lawyer go negotiate this case to the extent that he wants to or you want to. Or you can waive your right to a lawyer and I will arraign you.
I believe I can just handle the arraignment, just telling me my rights, correct?
You can say it again. I'm explaining to you the charge, possible penalties, and your rights.
I can handle this.
You know the form he wanted you to sign that you declined to sign because for whatever reason you decided you wanted to be a little bit more belligerent?
No, not that, sir.
Well, you didn't want to sign the advice of rights form. You can read, right?
I mean,
You can read, right?
I can read.
Then why didn't you want to sign the advice of rights to
I
be
just
handed
didn't
in?
see why would I have to sign to say, hey, I want my rights, so I wouldn't. Well, why would I ever have to sign to keep your rights?
You just want to engage in this banter. It's kind of funny.
Sir,
It's kind of funny, really. I've seen enough of this and
please don't.
I don't-
need to let everybody else do that.
it's always a good sign when somebody doesn't want to sign the advice of rights that they're going to come up here and interview with. I'm just a little conduit. I didn't have anything to do with the ticket.
No, sir.
I don't have anything to do with writing the law.
Not.
Right. Let's make this easy. You're going to answer, yes, I want a lawyer, or no, I don't want a lawyer. And if you tell me, no, I don't, then I'm going to go through your rights. And I'm still going to read all your rights to you because you were too belligerent to handle and sign the advice of rights that he asked you to sign. So do you want a lawyer, yes or no?
At the end of the day, no, sir.
Okay, do you want me to arraign you then without a lawyer?
I would like to prove jurisdiction, sir, so we can proceed.
This is
You're
the
gonna-
turning point where the defendant's strategy fully collapses under the weight of actual courtroom procedure. The defendant keeps demanding that the court prove jurisdiction, as if jurisdiction is something the judge must verbally establish on command before proceeding. But that's not how jurisdiction works. Courts derive jurisdiction from law, statutes, geographic authority, and subject matter, not from satisfying a defendant's personal standards in open court. In other words, the court doesn't need to prove its authority just because someone says they don't recognize it. And when the defendant starts talking about unrevealed contracts, we see one of the hallmark traits of pseudo-legal arguments, introducing vague legal-sounding phrases that don't actually create a valid legal challenge. They may sound profound, but they carry no procedural weight. Meanwhile, the judge remains grounded in the actual law, reading the charge, outlining penalties, and preserving the defendant's rights. That contrast is striking. The defendant is arguing theories, while the judge is handling legal realities. At this point, the defendant likely believes he's creating a record in his favor, but from the court's perspective, He's simply refusing to engage with the actual process. That's a dangerous position, because the case keeps moving forward whether he participates meaningfully or not. And viewers, ask yourselves this: when someone refuses to accept the rules of the courtroom, who do you think really loses, the judge or the
In
defendant?
accordance with your record, your vehicle could be, or I might have to be immobilized depending upon your record. Do you understand that?
I understand you mean staying under your jurisdiction, no?
I said, do you understand what I just said?
Competent to what you,
You understand what I said, right?
I'm competent to what you said.
I don't know what the hell you're talking about. Competent, what do you mean?
You have another word for understanding? Sir, I'm just gonna navigate and keep my rights in your courtroom, sir.
It's not my court. I don't see anywhere in here where they deeded me the property. I've never referred to this, not one time, as my courtroom. It's not my courtroom. Well, that just means I'm a little occupant. I'm a tenant here. They gave me the privilege of sitting here for the last 32 years. You see that guy? That was my father, and he was here for 18, the first and best judge of the court ever. The guy in the back there was my grandfather, who was a heck of a lawyer and the Wayne County prosecutor and a justice of the peace. Now, I'm not playing with you. Do you understand what I said?
I'm competent to what you said, sir.
Good. All right, now you have the right to remain silent. That's a big right. You have the right to remain silent. You do not have to say anything. If you choose to say something in or out of court, whether orally or in writing, it can be used against you. Do you understand?
Competent.
You understand you have the right to be represented by a lawyer, not only today, but at all subsequent court proceedings. If you cannot afford a lawyer, I will be more than happy to provide you with one at public expense. If you ever choose to submit the question with law enforcement officials, and you don't have to do that, you have the right to be represented by your lawyer. Do you understand that? Do you understand that you have the right to a trial in this case? You have the constitutional right to a jury trial. At that trial, 6 people would be impaneled. All 6 would have to agree that you're guilty beyond a reasonable doubt in order for you to be convicted. At a trial, you have the right to remain silent, and that silence would not be held against you. Do you understand?
Sir.
And do you understand that at a trial, you could bring in your own witnesses? You could use the subpoena powers of the court to bring in those witnesses. You could testify or remain silent. If you just testify, that's your choice. You can cross-examine prosecution witnesses. You can use the subpoena powers of the court to bring in those witnesses. And if you plead guilty at any time, we're not going to have a trial, and we're waiving the presumption of innocence. You're waiving the requirement that they prove you guilty beyond a reasonable doubt. Do you understand?
Competent, sir.
All right, so I will go ahead and I will enter a not
Sir, can I
guilty.
ask another question? I did present a motion.
I'm gonna, hang on. I'm gonna go ahead and enter a not guilty plea for you.
Well, that would be personal off the bill, sir.
Okay, would it? You want me to enter a guilty plea for you? I'll ask you how you plead. Do you plead not guilty or guilty?
Well, sir, I wish not to plead without proof.
The court is entering a not guilty plea.
I object to it.
Now we've reached the moment where the consequences become real. Despite all the objections, interruptions, and jurisdiction arguments, the judge proceeds exactly as the law allows, entering a not guilty plea, setting bond conditions, and assigning the next court date. This is the practical reality many people misunderstand. Refusing to cooperate doesn't stop the legal process. It simply means the process moves forward without your input shaping it. The judge is imposing structured bond conditions, restrictions on travel, compliance with the law, and substance prohibitions, not as punishment, but as terms for remaining out of custody while the case proceeds. These are standard judicial controls, and violating them could result in immediate consequences. What's remarkable is how little the defendant's earlier resistance actually accomplished. All the arguments about summonses, jurisdiction, and special appearance changed nothing about the outcome at this stage. The court still asserted authority, still set terms, and still advanced the case. This is one of the clearest lessons from hearings like this. Courtroom defiance may feel empowering in the moment, but procedure always wins over performance. And now the stakes are even higher, because if the defendant keeps relying on these tactics moving forward, the penalties may escalate fast.
No marijuana, no illegal drugs, no marijuana either, or illegal controlled substances. Also, again, you cannot leave the state, cannot violate a law, you must appear in court as directed. Heather, give me a date, please.
March
Sorry.
18th at 9:30?
I'm sorry, what, the 18th at 9:30?
Correct, Judge.
If it's the same question, I'm not going to answer it. If you
No,
have a
sir.
different or new question, I'll be glad to answer it.
Well, I'm a medical marijuana card patient holder, and I use marijuana for medical purposes.
Well, you're going to have to provide proof of that.
I can,
Um,
and I can do that now.
let me put it to you this way. As of right now, while I honor the medical marijuana law, even though I might disagree with it, I'm going to tell you no medical marijuana. And the reason is that the allegation here is that you were under the, I want to be clear about this. If this involved alcohol, my standard order says no alcohol, marijuana, or illegal drugs. I would never stop somebody from using medical marijuana if they have a valid medical marijuana card. The problem here is, and a court on appeal can hear me nice and loudly, the allegation here is that it was marijuana and that your ability to operate that motor vehicle was significant, was impeded. In other words, you operated with the presence of drugs in your system, which is illegal. So therefore, even if you have a valid medical marijuana card at this point, I'm denying you the ability to use medical marijuana. And it's solely on that basis. Again, if this involved alcohol or some other type of drug, at least the allegation on the ticket is that you're under the influence based upon marijuana use. So I'm not allowing you to use medical marijuana right now. We will set this for a pretrial. You can file any motions. You can hire a lawyer. You can demand, you can ask for a court appointed, in which case I will do that. So you're going to go down the hall, get your court.
What was the date again?
March the 18th.
This hearing is a textbook example of how quickly pseudo-legal arguments fall apart in front of an experienced judge. From the opening moments, the defendant tried to challenge identity, question jurisdiction, and avoid the standard arraignment process using arguments often promoted as legal loopholes. But the judge methodically pushed through each step, advising rights, entering a plea, setting bond conditions, and moving the case forward exactly according to procedure. And that's the most important takeaway here. The courtroom runs on law and procedure, not on rhetoric, semantics, or internet legal theories. The judge did not need to win an argument. He simply needed to apply the law, and that's exactly what happened. Meanwhile, every attempt by the defendant to resist the process only reduced his credibility and gave the court more reason to tighten control. In the end, the defendant walked away not with a dismissal, not with proof the court lacked jurisdiction, but with formal charges, strict bond conditions, and a scheduled return date. That's the harsh reality of trying to fight legal procedure with bad legal advice. The bigger lesson here is that confidence is not competence. Sounding certain in court means nothing if the law is not on your side. What do you think? Was the judge too harsh, or was this exactly the right way to handle someone refusing to cooperate? Let us know in the comments below. And if you found this courtroom showdown as unbelievable as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.